All right, let's take up the next matter. This is Rosemary Blair versus Joseph O'Connell.
O'Donnell, Your Honor.
O'Donnell, okay, it says O'Connell here, but I wrote O'Donnell. Joseph O'Donnell, I put O'Connell.
Thank you, Your Honor.
I think it's a typo on the sheet. A typo on the judge.
Oh, okay.
All right, this is filed as a termination of tenancy action. Lori Hines is here with the plaintiff, Rosemary Blair. Also present is Douglas Kuhlman, who's a zoning enforcement officer for Fabius Township, among other things. This was a lease option to purchase on a property at 11247 Lakeshore Drive, Three Rivers. Term began November 12th of 21 and terminated December 30th of 22. This action was filed on December 20th. The plaintiff contended, now there are two Lakeshore Drives. There's one at Fisher Lake and there's one at Corey Lake. This is the one at Corey Lake, and this is a very fine home, or at least it looks like it in the pictures. The plaintiff alleges that the defendants are trashing the place, have removed the appliances, furniture, and want to terminate this lease as soon as possible. Ms. Hines, is that correct?
That is correct. Attached to the complaint also are two letters written by Robert Yonkers, an attorney, that basically laid forth the notice option to terminate the lease agreement. One letter is dated September 9th. The other letter is dated November 23rd. Doug Coleman has been actively involved in this matter as well, because so many things have happened criminally in this house that the sheriff for St. Joseph County will not pursue. My client has changed the locks twice. They've been broken twice. We know they've been in it. Basically, the house has been gutted. The house has also been condemned. Doug can speak to that as well. This
beautiful house has been condemned?
Yeah. So there's issues with it because of some tree damage and some other damage that's been done. So my client is in.
Let me stop for a minute.
Okay.
She was locking the house up while they still had a valid lease. The lease was valid through November and the locks were being changed in August. So I have some concerns about that, but all right, Mr. O'Connell, Mr. O'Donnell, and Ms. Bowers, what's your position?
Your Honor, I mean, this is a very personal case. This went on. Originally, we purchased this home back in 2021. And then my father got sick. I had to cancel the deal and she cashed the escrow check. And then the following April, her daughter contacted me and said, my mom hasn't sold to anybody else. She waited for you. You know, I'm sorry to hear about your dad passing. I contacted her. She said she needed money up front to hold it. We gave her $50,000 at first. And then we agreed to pay her $100,000. And then she was going to hold it. And then once she finished off paying off, she said that she had some debt she had to take care of. And she had a few miscellaneous things she had to take care of. We paid for all of her boats to get out of Hawk. They were both in storage for years. I paid to get them going again. I had them insured. But then she also signed a promissory note when we gave her an additional $35,000 for $85,000 because she was kind of like not sick at the time, but she was sharp at the time. I don't know what her mental capacity is now, but at the time. And then she took another 35, and then we paid her the additional this July and this January. She was given up to $120,000 total, which she didn't give you a copy of that lease option.
Oh, just a minute. Just how much money have you paid her in total?
Over $120,000 in cash.
Your Honor, that's a complete and utter lie.
No, it's not. I have proof right here. Signed document for $85,000. I have a promissory note for.
Hey!
Sorry, Your Honor.
Shut up!
I got it. Sorry.
Both of you. This is a court proceeding, and you don't just get to shout over each other. they're contending that what you've done is a lie. Now, the video of this house on Zillow shows it to be a beautiful lakefront home at Corey Lake with a purchase price of about $600,000. And you have a lease option to buy and you have not completed it. So it may not matter how much money you've paid her. They contend you've taken the stove, the refrigerator, the furniture out of the house, and the house has been condemned.
Your Honor, I paid separately for all that furniture. I have a receipt that I paid her for every bedroom, for every furniture, every piece of furniture, that whole house I paid for.
There are two sides to every story.
Oh, I get that, Your Honor, but she also removed her washer and dryer. She removed, and she had her dishwasher. She stole my snowmobile. She took our snow blower. She took our wood.
All right, well, obviously there's a lot to this.
Oh, it's gonna be close to, she has 18%. She owes us on that money too. That's in these promissory note that she's got to pay interest on that.
All right.
So, and I did a title search, and she owes $158,000 federal tax lien on this house that she did not disclose to us. And I have the tax lien. I pulled the title work a month ago, and I almost cried. I got fooled, Your Honor. I had blinders on. This is a beautiful home.
And the house was not.
And the house was not, and when we purchased it, it was not worth that value either. We purchased it 2 years ago when the value of it on Zillow was
Well,
maybe
I
$485.
I wanted to see which Lakeshore Drive this was, the Fisher Lake one or the Corey Lake one. Both of them are full of very nice homes.
And Doug can tell you that he was through our house.
Stop.
Oh, sorry.
We're not sitting around the kitchen table. They're providing testimony and evidence in a court hearing. So I'll give you a chance to speak. Don't interrupt me and don't
I apologize, Your Honor.
I'll ask you to speak.
Sorry.
So I looked it up and I recognize the house. Let's hear from Mr. Coolman. Doug, would you raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief. Would you state your name?
Douglas Kuhlman, Kuhlman.
And what's your position in Fabius Township?
I'm the zoning administrator, code compliance officer.
I can't hear you very good, Doug.
No, not at all.
Have you condemned this property at address? It's not on the
11247.
yeah, 11247 Lakeshore Drive.
We did condemn it, Your Honor. It has since had minimal repairs to get that placard removed. But there is a tandem case to this, Your Honor, that you signed an order on. It's case number 221650 Ocean and Nora. So back in August of 2022, we were out there because there was a tree that came down on the property. State Farm sent out an engineer. And so myself and building inspector Joe Wicki was out there when the engineers were present. This south side, I believe it is, of the house is a huge glass wall at about a 45-degree angle. All the supports that supported that glass wall down on the foundation, all of the bolts or brackets had been broke by this tree hitting it. And so the engineer said that yes, it was a potential that this glass wall could fall in. And if it did fall in, the only place it could go would be into the structure. So because of that, it was deemed as condemned. Looking at the property record from the county records, it indicates that Rosemary Blair was the only person on the title. And so we did issue a municipal civil infraction to Miss Blair. She signed a consent order resolving the matter, which is under case 221650 ON, that was signed by you September the 6th of 2022, that indicated that nobody could be staying or living in that dwelling. So I believe that under our direction that Miss Blair was instructed that she had to keep people out. is why she was changing the lock on the door.
Oh, yeah.
That's him.
Oh, okay.
Your Honor,
Yes,
I was out there that day with that engineer, and that engineer did not say that the tree caused that damage. He said that damage was pre-existing where those pins were out. He did not say the tree caused it.
all right, well.
I wanted to clarify that,
regardless,
because that's a big
there's
part of this case.
there's-
Rosemary knew about this before the fact. She
Okay.
misrepresented the whole thing.
Mr. Coolman, when you were there, was the inside of the house in good order?
As indicated, there was some appliances missing and stuff, but it wasn't, one of the big concerns is, and I can screen share if you'd like, there's a huge beam on the inside of that structure that had a significant sag to it. But overall cleanliness, it was clean, yes.
I could do this all day.
All right. Well, we have a mess.
Your
We have
Honor,
a lease option. Yes, stop. We have a lease option to buy. The plaintiff says she wants to terminate this tenancy because they haven't completed the terms of the lease. Defendant says we've paid her a substantial amount of money and she's misrepresented the habitability and transferability of the property. So, Mr. O'Donnell and Ms. Bowers, let me ask you this. What do you want? Do you want to complete the purchase of this house, or do you want to walk away from this deal?
I mean, at this point, this house almost feels cursed to us. I mean, this has cost us everything. I mean, and I honestly, I'd like to continue. I'd like to have the home. I mean, but I mean, if not, I mean, there's a substantial amount of money there. You know, I mean, it's either way. And if it was just condemned and it was just a minor little thing that condemned the building, then I think that she knew about that condemnation. And I think this was a complete misrepresentation from the start. I mean, she got a lot of money out of us. And I mean, Carla's mom had to deliver 20,000 to her. I have pictures of her with the cash in her hands, so I can show you that she did receive the money. And I have pictures of her. We have plenty of evidence like that. But during the pandemic, it's on Rocket Law. We didn't have access to attorneys, but I did get it notarized in case anything happened.
Well, they also allege that you were in there a few weeks ago and you took a smiling selfie of yourself and sent it to her. What was that about?
That was the selfie and the thing. That was an accident. I didn't mean to send that. It wasn't supposed to go to Rosemary. That was just, I take pictures every time I'm there. I have pictures of every time I've been in the house, when I came in and when I left, to make sure that if this was here, that if she claimed anything, she took everything out of the house. There was a state trooper there that watched me padlock the garage with everything in there. And then she tore that padlock off and gave away, or had them take my snowblower, my swim mattress, all of our wood. I mean, all of our rafts. I mean, she stole everything. I mean, it's tens of thousands of dollars worth of total damages in property for that she had. Just, I don't know what she did with it. The snowmobile, she had a tow impound come, and I don't know how that's possible because we weren't gone that long. I mean, everything she's done. Carla, that was a no. If you ask Doug, they did a no-knock search on her, and while she was in bed, because Rosemary harassed.
Well, they can do a administrative search warrant, but for one
But Rosemary
thing,
knew she was hard of hearing and that she just worked a 14-hour shift.
I don't think they knew you were in there.
Yes,
I
Rosemary
didn't know
knew.
you were in there. I signed this consent order with Rosemary Blair in August
She's a fraud, Your Honor.
and September without understanding there were tenants living in the house. Laura, your client does not have clean hands here. In this case, there's a much
Your
more-
Honor, you're taking their word against mine.
All
Maybe
right.
you need to talk to
Doug
Doug.
was there.
Coolman.
Doug
He
was there
knows
the
what
whole time.
you've been
Just a
through.
minute,
Ask
just a
Doug.
minute. She locked the doors, which violates the Landlord-Tenant Relationship Act. The house was condemned with tenants in it, and I didn't know there were tenants in it. That much
And they
I know.
received a letter, Your Honor, of September.
No, we did
9th
not.
Of that
All right,
notice.
Mr.
from the-
O'Donnell, just a minute.
Sorry.
If you interrupt one more time, I'm gonna make you go sit out in the cold and speak through the window when we open and close it. Ms. Hines, this is your opportunity.
Your Honor, they were given a letter of September 9th, noticing them of the condemned property that was mailed to them by an attorney, Robert Yonkers. Then again, on November 23rd, they got another letter saying of all the damage that had been done, failure to pay the rent, the taxes, shutting off the utilities, My client is very elderly. She has no assistance. She has not removed anything from this home. These people have done everything and anything to give her grief. She is so stressed out about this. She's worked with Doug. I think she probably communicates with Doug at least once or more a week. He's been out to the house. He knows what frustration she's been through and the hell that she's been living because of these two. She just wants the property back. She was not paid the amount of money they're saying that she's paid. To me, she's told me that they've only paid $25,000. That's all she has. She did say they knew about the federal tax liens. So that's a lien against the property and they were aware of that. So all she wants is to get the property back. Can she even do anything with it? I don't even know. But at this point, they've not met the terms of it. They were given notice twice, September 9th, November 23rd, that they were in violation of the lease agreement, and she wants possession of the property back.
All right, well, let's unpack that. The September 9th letter, I guess we'll assume it's a notice to quit. Rosemary Blair has asked us to contact you regarding the above referenced lease with option to purchase. She informs us that the property has been condemned by the city of Three Rivers. That's not accurate.
Right.
This is to advise you, Ms. Blair is exercising her option pursuant to the terms of the agreement to terminate the lease. This is 20 days notice pursuant to the destruction or condemnation of the premises clause on page 2. If you do not vacate that property within that time, we will pursue any and all legal remedies, including but not limited to eviction. According to what the pleading said, the property was locked in August. They were locked out in August. All right, so assuming they're alleging, now the lease isn't up, purchase to buy isn't up until sometime in November.
December
But this
30th.
is September. So the next letter is November 23rd. And they enclose the earlier letter. Your acts of abandonment include, but are not limited to, failure to pay the rent or taxes, shutting off the utilities, moving all of your personal items and belongings out of the home. This list is illustrative and not exhaustive. She further informs us that if she legally took steps to secure the property by changing the locks, you unlawfully responded by breaking into it and have indicated, despite your clear abandonment of the property, that you own it. They still had a lease option to buy, and she locked them out in violation of the Landlord-Tenant Relationship Act. She also advises us there are missing appliances and furniture that belong to her. This is unacceptable. You're instructed to immediately vacate the property, cease and desist from re-entering, and reimburse Rosemary Blair for all damages suffered. You abandon the property and no longer have any legal right to occupy it. If you do not, we will advise her to pursue any and all legal remedies, which is what we're doing now, and a cause of action for injunctive relief, conversion, malicious destruction of property, costs, sanctions, and attorney fees. Well, that's easy for Mr. Yonkers. He's not here. Well,
Yep.
all the heavy lifting.
Yeah.
But anyway, there's issues about the nature of the lease, the extent of the lease, what's been paid by who. Is there an unlawful lockout of the tenants? I didn't give her the authority to do anything. And as a rule, a landlord can't simply say, well, my lawyer told you to move and you didn't move, so I'm locking the door. There's a step in between, which involves me, the judge, which has the authority to tell you to not go in there. So you've got your story. Now, Lori, what do you know about the state police removing a snowmobile and other property from the garage?
I know nothing about that. I do know that she called the 911 many times to get assistance for property that kept coming missing up from her property that came missing from the home and damage to the home. But I'm not aware of any state police coming to the home with a follow-up. The sheriff, I know, will not go out and deal with any of that either because they say it's a landlord-tenant issue and they won't get involved. Now, Doug might have some knowledge of a state police. Like he's been very involved in this whole action. Kind of like a township layperson almost for Rosemary. So he might be aware, but I am not aware of any police or trooper going to the home.
Well, let me go to Doug for a minute. I'll come to you, Mr. O'Donnell.
They wouldn't.
Did
talk.
you know that when we did the agreement on the zoning case back in August, that O'Donnell and Bowers had a lease option to purchase this property?
The only thing that I knew is that they were in there and that there may be some type of an agreement there, but when I looked at the county records, there did not indicate anything. I would clarify, just for your knowledge, that when I did the administrative search warrant on August the 12th of 2022, it clearly indicated in this administrative search warrant that the owner of the property is Rosemary Blair, and that it is understood that Joe O'Donnell and a Carla Bowers may be occupying this parcel. As a result of our search warrant and talking with the engineers that did, as you're familiar, we a lot of times do unsafe for human habitation. In this case, because they said it could be in the state of collapse, which obviously could cause death, we condemned this property, and that placard says keep out. And so I did assure Miss Blair that she needed to do whatever effort she could to make sure nobody got into this building until it was properly stabilized. I do believe.
Were the residents notified of this?
So on the day that we were there, it's been indicated that we did an unannounced, we did knock several times. The St. Joe County Sheriff's Department was there with us. The sheriff deputy kind of was the leader, if you will, going through, because we several times knocked, announced, we opened the door. There was an unsecured sliding glass door. We opened it up. We announced several times that we were there with an administrative search warrant. It wasn't until the sheriff's deputy walked into the one bedroom that it startled Miss Bauer, because she wasn't there sleeping. And he explained to her that we were there for an administrative search warrant, and obviously she was startled.
Who made the complaint regarding this?
Miss Blair contacted me because she had this tree fall on her house, and that she was having difficulty with State Farm insurance because of the damages. And so the building department and I went out and did an inspection on it to find out the condition of the structure. So again, as a
All right,
result, there was
so
a
someone from the township didn't call you, the homeowner called you because she was having difficulties with her insurance carrier, and then she got you to condemn her house with her tenants in it?
based on the inspection that we did after the administrative search warrant, talking to the engineers saying that it was in the state of collapse. Yes, we did condemn the house based on the condition of the house.
All right, were repairs made to the extent that the condemnation order was lifted?
Yes,
All right, so then theoretically, the tenants would be able to go back into the house.
correct.
When was the condemnation order lifted?
Let me see if I can find that for you, sir.
They never. Got one of the orders 2 times they came out there. It wasn't just the first time.
Were there repairs done?
You
Were
passed.
repairs done?
I can't.
Looks like the construction crew is out there and stabilized these posts onto the foundation on November 16th of 2022.
Doug, is there still a placard on the home that it's still condemned though?
I don't know. I have not been out there, but Joe Wiki advised the construction crew that they couldn't.
No,
remove
it's
that
gone.
placard.
All right,
As of November 16th, yes, there was a placard still on it.
all right.
All right, so if the landlord owns the house, the landlord causes the house to be condemned, So the tenant can't live in it. The tenant doesn't owe any rent during the time the property was condemned. Talk about abatement of rent. So from August,
Your Honor,
September,
there wasn't any rent being paid.
well, okay, theoretically, and we've got this purchase rental agreement, the terms of which have not been met. Mr. O'Donnell and Ms. Bowers contend they've paid a large amount of money to the plaintiff, but the final terms of the agreement have not been met. So if push comes to shove, Mr. O'Donnell, you haven't dotted all the i's and crossed all the t's in the agreement. And ultimately, she may retake possession of this property. There are a number of other issues that are yet to be resolved. So now, what do you want to say?
Two things, Your Honor. First, with regarding Doug, he was there, and Rosemary didn't just call the first day and have Carla harassed. They passed the first day. They went through, the house looked beautiful, everything looked good, it was fine. She called, had an engineer fly down from Traverse City the next day to do another or whatever you want to call it. They know Carla can't hear. And she was there. I showed up during this inspection when the engineer was there. And this engineer was like, this was pre-existing. That's in Rosemary told him exactly where to go to look. I didn't know. There's 2 bottle jacks in the corner of the house. They went right down there, and I even have evidence here. She lied to us to take pictures of everything in the refrigerator that she submitted to the insurance company. I mean, this was insurance fraud too. I mean, there's a lot more involved with this. And I did, when we gave her the final $100,000 total, she signed that we could close on the 4th of July, that after that we'd start our 3-month period. And she has that signed somewhere. I'm sure she's not going to show it, but I do have a picture somewhere. I'm just trying to locate it from her house.
So you've given her, I'm assuming you have receipts for this $120,000 that they paid to her.
Yeah, we have from her, handwritten, and I have photos of her taking the money too, and records from our cash coming out of our accounts too. It was taken from my, inherited IRA. And
then you mentioned some sort of promissory note. What is that?
I had her sign when we got to $85,000. This is during the pandemic. I had her sign because if something would have happened to her, I told her her kids could turn around and, this is way too much money. So she signed that aside from everything, and we got it notarized, me and Carla, that we'd already given her $85,000. And that promissory note was signed and notarized on 11/15/21, that she had $85,000 that she'd received that day, that she got a total of $85,000 cash from us.
All right,
and then that went up to
promissory note is an offer to repay it. So
that was just in the event. And then in the promissory note says it was contingent upon this closing. It was the best we could do in a limited amount during the pandemic to protect our interests. We didn't know really. We did, it wasn't like we could go out, there wasn't much going outside at the time or interactions.
So
and I
on that
blinders
day,
on
paid her $85,000. And then you paid a $20,000 payment and a $25,000 payment.
It was at the 85. Then there was a 15,000, which brought it to the 100, and then there was the other payments were, I think, a 10, a 5, and then I think I gave her 3 or 3,500 in July. I'm not sure, but I was giving her about 2,500 a month. Your Honor, I also put her on. I gave her a credit card for $5,000 to help her out because her children. She told me her kids were helping her out, and I brought her food on Christmas. I mean, this was very personal. I mean, this is not like we were just some tenants. I mean, she gave us the keys to the home. She gave us everything. I mean, we'd already closed this deal at Zimmy's Bar.
Well, the bottom line on this, 1, we have to adjourn this matter for at least 7 days. And 2, this is going to take a half day of testimony. There are a couple of issues. 1 is her ability to reclaim possession of the property. Her claim is that you have not executed the terms of the lease option to buy. Your claim is that there may be fraudulent representations as to the property. And I don't know about that.
Can I
Ms.
say
Bowers?
something? We were never told that condemned state was lifted. We were never told that there was anything done to rectify, like the condition of the home. Joe tried to reach out to Rosemary several times. She would not like communicate with us or with him about anything going on with the home. She had our information. She could have at any time talked to us about this, and she refused to do so. I don't know. I don't even know where, like, we were fine one day and then we weren't. I don't know. Yeah, they did come out twice. They came out that day that I was sleeping. I work overnight as a nurse, so I was in between shifts, and when they came out, I was sleeping in the bedroom. They came out the next day and did the same thing, an unannounced visit, and passed through, which was fine. I had no idea what was going on. There was no communication here about any of this going on with the property.
Your Honor, they got communication, a letter of September 9th and
We never got,
you
you
never
never,
23rd.
Stop. Jesus, stop it. I'm gonna set this for a hearing, and we're not gonna do it on Zoom. I'll but put you all in a room and let y'all punch each other, and then you'll all feel better. This is complicated.
They never paid any of
We're gonna find a place to put it, which is not gonna be easy. I'm going on a trip. Ms. Hines' calendar is very busy. And I don't have a lot of days that are just sitting around without me having lots of stuff to do. I'm going to continue this to, Lori, are you available on Friday, January 27th?
I gotta go look at my calendar.
Your Honor,
Yes?
there was also a state trooper that
Stop.
came.
Stop, she's not here.
Okay.
Oh, I potentially will have a trial that day in a divorce matter because we did not get resolution at mediation.
As indicated, these things are very hard to schedule. That would have been an ideal day.
Yeah, I mean, tentatively, but we did not get, it would be off my calendar, but we did not reach an agreement at mediation, like one of my very few that did not. So it is set for trial all day in Judge Stutzman's court.
I'm going on a trip in January, so I've used Wednesdays for landlord tenant cases.
Right.
Wednesday, the 11th is full. Wednesday, the 25th is full. The morning of the 27th is full. The afternoon of January 30th is full. Let's see what I got for February 1st. How are you for Wednesday afternoon, February 1st?
That one works. We just sent my 2 criminal cases 11 that day.
Yes, Hannah Rawson. All right, I'm going to continue this to February 1st, 2023, and I'll block the entire afternoon.
Thank you.
It's going to be live, not Zoom. Mr. O'Donnell, you could benefit, and Ms. Bowers, from having legal counsel. You are unrepresented. You may wish to subpoena the Michigan State Police officer that seized your snowmobile. You may wish to get receipts to show all the checks that you've paid. There are so many issues here, I can't even quite name them all, but one is who gets possession of the property. Second, is there a violation of the Landlord-Tenant Relationship Act and an unlawful lockout? Third, are there money issues? Who owes who how much money? And what's the current status of the property? You are the lawful leaseholder. they claim that you have abandoned the property, but you're the leaseholder and I have not ordered that you be evicted. If the house is no longer condemned, you have paramount right to possession of the property. It was said that the utilities were turned off. What can you
Right.
tell me about that, Ms. Hines?
I have it only on the information that was stated in the letter of November 23rd that all the utilities were shut off. And there was no rent that had been paid. That's where I have the knowledge. And I think my client has a file showing that the bills had not been paid as far as the utilities. She's got it right now in her possession. She just opened the file for me.
The home was
Mr.
condemned and we weren't allowed back in. That's why the utilities were shut off.
All right, are they still off?
Go off 10-5.
She shut off our garbage before any of this. On August 2nd, she shut off my garbage and they sent me my check back and said that she called and they'd never had this happen, but she had our garbage canceled. She literally had it canceled and taken out of my name before she
And
even
I've
did any of this stuff. And this lady's, she's,
Your Honor, she has pretty good notes of all the utilities and when they were shut off and when they were switched.
Well,
on.
are they shut off right now?
Are the utilities shut off right now?
No,
No, they
and
are
I
not.
just paid the last, I've been paying every bill. Here they are.
She's been paying the bills. They have not
What?
been shut off, Your Honor.
Nope.
She's got the bills right here. They're in her name.
And the gas, and I had everything. The utilities I had to pay. I had to pay the,
Only
What
after
do you
you
call
kicked
it?
us out,
The,
only
Stop,
after
stop,
we
stop,
left
stop.
because it was condemned.
Stop. All right, did you
I know,
change
I know,
the
I know.
utility-
I have
now,
proof.
Mr. O'Donnell and Ms. Bowers, were the utilities in your names?
Yes, they were until she had us kicked
They
out of the
wouldn't
home
give
when it
them
was
any
condemned.
further-
And then
She
I had them taken out of my
the
name.
garbage, she had the garbage shut off a month
Stop.
before the utilities.
Stop. You guys aren't very good at this. And there's a number of people waiting for their cases and you're shouting over each other and talking over each other. I'm asking a question. Let her answer the question, and then we'll try to figure out what's going on, whether we have an unlawful termination of the utilities and reestablishing them in her name. Ms.
Your Honor.
Bowers, stop. Ms. Bowers, were the utilities in your and Joseph's name through this summer?
Yeah, and I have been paying them and I have proof of that.
All right, when I say utilities, that would be the electric company. Is it
And gas.
propane heat or is it gas?
Gas and electric.
All right, what is it? Is it gas line or is it a propane tank?
Gas line.
Gas.
Gas line, natural gas.
All right, so the electric and gas were in your name.
And I have proof that they had been paid up until we were kicked out.
All right,
Your
did you
Honor,
take
and,
the name off the utilities?
I took them out of my name.
All right, when was that?
I think the one I had paid up through November. The gas, I believe, and the electric was in October. I have proof of that.
She shut off our garbage in August 3rd.
Yeah. I
Your Honor,
got
I'm
that
looking
3
at a
times
garbage
already.
bill that's actually in Rosemary's name that goes back to early 2021. All of these garbage bills are in Rosemary's name.
All right,
Well, I can show my proof.
all right. So is there current heat in the
Yes, Your
building?
Honor. Yes, there is.
All right, I'm continuing this to February 1st. No one's to be in the property between now and February 1st. We're going to maintain the status quo. We'll see what I don't even know how to get all around it. If there's a lease purchase to price and it's in here, what the purchase price is, but
It says right in there, the
provisions-
85,000.
No, the purchase price was
Yeah,
450,000.
450,000. It's probably assessed as substantially more than that.
Yes, it is.
Now, a $450,000 purchase on this price was a steal.
Not for the condition, Your
Pictures
Honor.
that I saw. All right, but if it's got all this structural problem, maybe not. So we'll sort of, anyway, no one's to be in the house. Utilities shall remain on. The plaintiff shall pay for those in the meantime, and we're gonna sort this out. Mr. O'Donnell and Ms. Bowers, you could use counsel. One, you don't understand the law. Two, you don't know how to conduct yourself that well in a courtroom. Ms. Hines is a very experienced lawyer. She knows real estate law. She knows landlord-tenant law. And she knows how to subpoena witnesses. And you guys don't. And so it's up to you. You are entitled to represent yourself. But when we're at this hearing, the rules of evidence are going to apply. Hearsay is not admissible. If you have things like receipts or check stubs or promissory notes or that sort of thing you want me to see, you're gonna have to bring that. But our next hearing is gonna be on February 1st. They are asking that your right to have this property be terminated. And if they get what they ask for, it would be 10 days after February 1st. There may be other ancillary issues about who owes who how much money, or was there a violation of the Landlord-Tenant Relationship Act? But the real question is who gets the house? And she wants it back and she wants you out of it. You're not to remove any piece of property, even a screw head, from this property between now and February 1st. And I'm gonna block out the whole afternoon for this unenjoyable task of trying to untie this knot. So for the meantime, we're gonna leave things exactly the way they are. And there are two sides to every story. We're gonna put people under oath. And we're gonna see if we can discern what the status of this is. All right, no one shall occupy the premises or remove anything from it prior to that date, or you will be in contempt of court. You'll get a new notice for that date. Thank you, Ms.
You, Your Honor.
Hines.